Alrighty, it is 6:05. I think we're going to go ahead and get started just to be mindful of folks' time. Can everyone hear me okay? Beautiful, thank you. Okay. Good evening, everyone. I am Chelsea Infinity Gonzalez. I use she, they pronouns. I am the Public Policy and Advocacy Director at the ACLU of Connecticut. Thank you so much for joining our office hours for the month of June. We are also using this time to cover our 2026 post-legislative session recap. Want to just give some context, level set a little bit. So our Public Policy and Advocacy Department at the ACLU of Connecticut is one that houses our policy advocacy and our organizing work as well. So we work often with lawmakers, elected officials, coalition partners, community advocates, and community members to advance policies at the legislature, at the Capitol, that protect and expand civil rights and civil liberties. So we work on a range of various issues. And we also organize people to take action and build collective power in the state of Connecticut. Our office hours are something that we do typically monthly. And the goal is just to create a space or a container for our supporters and advocates and partners to connect with us on a monthly basis, to ask questions and hear updates on the range of issues that we work on that affect civil rights and civil liberties here in our state. And tonight we're going to focus on the recently now over legislative session. And we're going to share some updates on our advocacy efforts, key victories and challenges, and where things ultimately landed on several of our core priority issue areas. Before we get started, I did want to share some general housekeeping notes. We will probably be covering a lot of information tonight, and I don't want anyone to feel, pressure to remember everything. You don't have to be an expert in every detail or in all of these issue areas. We are going to be sharing the slides afterward, and we will also share some materials that we've prepared to help guide the discussion today and provide some additional context on the laws that we're going to be covering. To also help us stay on track, we are just asking that folks hold their questions until the Q&A portion at the end of this presentation. You'll be able to submit questions using Zoom's Q&A feature, and we will do our best to answer as many as possible with the time that we have. In terms of our agenda, we are going to just begin with some introductions from folks on our public policy and advocacy team. And we also, if you see, we have Rachel here with us as well from our communications department, Rachel Moon, who is fantastic and is helping us with some logistics on the back end tonight. Once we get through intros, we are going to then transition and we'll provide some context about where things stood for us as an organization heading into this legislative session before walking through the outcomes of our core legislative priorities and highlighting some of the key bills that we worked on throughout session. So with that, I'm going to turn it over to my colleagues to introduce themselves, and I will start with Gus Marks Hamilton.
Good evening, everybody. My name is Gus. I use he, him, his pronouns. I'm the Advocacy and Organizing Manager here at the ACLU of Connecticut, and I'll pass it to Anderson.
Thank you, Gus. Good evening, everyone. Thank you so much for joining us. My name is Anderson Curtis. I'm the Senior Policy Organizer here at the ACLU of CT, and I'll pass it to my colleague, Jess.
Hey everyone, my name is Jess Zaccanino. I'm the Policy Counsel at the ACLU of Connecticut. I use she, her pronouns. My role as a policy counsel essentially means that I'm a lawyer, but instead of litigating in our legal department, I work with our public policy and advocacy department as a lobbyist at the state legislature in the policy world. So I'll pass it back to Chelsea Infinity.
Thanks so much, Jess. And can we transition to the next slide, Rachel? Thank you. So this is our public policy and advocacy team. Great people. And I wanted to also offer some additional context about this session that just passed. So this was a short legislative session. It ran from early February 4th to May 6th. So lawmakers had just 3 months to introduce bills, to work through differences, to essentially pass legislation that we needed them to pass. And that's a really tight timeline, a really small amount of time compared to a long session, which runs from January through June. And especially for really complex, complicated issues that require a lot of coalition building and public education, and also negotiations and conversations among lawmakers and stakeholders, right? At the same time, this session took place during a period where we're experiencing and seeing a lot of rapid change take place at the federal level. And there's a lot of decisions, that are coming out of the federal administration that were already affecting people here in Connecticut. And many communities were looking to state leaders, to our electeds, to provide protection where they could. And because of that, much of our work this session focused not only on advancing new rights, but also on protecting rights that already exist, that we already have here in Connecticut. Our goal was really to work to strengthen what we call firewall protections. So state laws and policies in Connecticut that help protect us as residents when federal protections are weakened or fall short, or, as we've seen, trickle down and impact us negatively or harm us here in Connecticut. For many of the communities that we work with, including immigrants, voters facing barriers to participation, and people who have genuine concerns about our privacy and surveillance and government accountability, the stakes this session felt particularly high. And in response, as an organization, we sort of pivoted from some of our usual core priority issue areas, and we decided to focus our advocacy on 4 key priorities. The first is protecting voting rights, especially at a time when we're seeing them be rolled back at both the state and a federal level. Defending immigrant communities, as we've seen, the continued targeting of our immigrant neighbors, immigrant families and communities in the state of Connecticut by this federal administration. Privacy and surveillance, we've seen the ways that our data has been weaponized in furtherance of this really extremist federal agenda as well. And lastly, strengthening government transparency and accountability, which I think goes hand in hand with, data privacy and surveillance as well. But essentially holding this administration, holding government officials, regardless of the type of official, the type of badge that they wear, accountable when our constitutional rights are violated. So the rest of our presentation tonight is really going to highlight what we worked on in each of those areas, where we started, where we made some progress, and where we ultimately ended up, along with what challenges remain. Can you go to the next slide, Rachel? Thanks so much. So before our session began, to again just offer some additional context and level set, before we sort of go into outcomes, I wanted to make sure that, we all sort of knew where we started and where we were even before session began. And so with regard to these 4 core campaign areas, 4 core priority issues that were our primary focus, voting rights was the first area. I shouldn't say first, in no particular order. Nonetheless, voting rights, our goal at the start of session or before session was really to make voting more accessible by allowing people to vote by mail without needing a specific excuse. And simultaneously, we also wanted to protect important voting rights that we had already won as a state, right? That includes early voting, which we fought incredibly hard for, and the Connecticut Voting Rights Act, which is a state law that we have here that helps protect voters from discrimination and barriers to participation. So after we as voters approved a constitutional amendment in 2024 that allows no excuse absentee voting, which is voting by mail without needing a specific excuse, we expected the legislature to take up that law that needs to put that change into practice, so to actually implement what we voted on. And last year, we got a skeletal bill that did nothing but simply remove excuses, and it did not move through the legislature. And so we ultimately didn't get that passed, which was pretty disappointing. And so at the start of session, this was an area that we knew we were going to continue advocating for, and we anticipated that there would be another skeletal bill introduced. The second core priority issue area or campaign area for us was immigrant rights and protections, or immigrant justice. And at the start of session, we were working hard to strengthen protections for immigrant communities alongside some of our immigrant rights partners to really limit the state of Connecticut's involvement in federal immigration enforcement. So at the start of the year, one major issue was whether state resources, including our National Guard, could be used to support immigration enforcement activities. And in December, some of our supporters may remember, and it's totally okay if you don't, we were in the middle of a pressure campaign. We were really urging Governor Lamont to issue an executive order or to consider or support legislation to ensure that our National Guard couldn't be used for immigration enforcement activities. And that's something that we were at the start of session, in talks with the Lamont administration about. And it wasn't necessarily moving, but we were still having conversations about the importance of this issue. And then third, data privacy and surveillance. Our focus at the start of session, even before session, was really establishing meaningful guardrails around what's called ALPRs, or automatic license plate readers. It's a type of technology that captures the license plate and other identifying information and data on every single, car license plate that passes by one of their fixed cameras. They also have mobile cameras. And Gus Marks Hamilton, when he talks a little bit about that area of our work, we'll talk a little bit more deeply about what that means and looks like in practice. But recognizing the ways that we have consistently been surveilled, particular communities have been, overly policed, overly surveilled, and the growing threat of and rapid deployment of ALPRs and the ways that our data have been weaponized, again, to further this administration's agenda. That was an area that ahead of session, we were working very closely with partners on, because this was a broader issue than even just immigration, even just, reproductive justice or LGBTQ plus justice and equality, right? This was a larger issue that we were working with a bunch of advocates on, specifically the Center for Policing Equity. We were drafting legislative language on a bill that could, for the first time in the state of Connecticut, regulate ALPRs and the way that our data is collected and also shared. We anticipated that this would be one of the primary privacy issues that would be considered by the legislature. So that was something that we were a little bit confident in there being legislative appetite around before session started. Nonetheless, we obviously had no idea where that was going to go, right? The last thing before session started that we were working on was government transparency and accountability. So one thing that was a longer term goal of ours or objective was to support creating a way in the state of Connecticut for individuals to be able to seek relief when government officials, whether state officials or federal officials, violate our constitutional rights. We view that as a really important goal because, it's important to have some way to seek recourse when your constitutional rights are violated. And right now, the way that it works federally is really limited to be able to, see any meaningful justice come out of that process. And so that's something that we were advocating for, but transparently did not think or know whether or not there would be legislative appetite for that. And so we were in conversation, in several conversations with legislators about that particular campaign area and issue. Our team is going to discuss over the next several slides the final outcomes that looked somewhat different than what we went into session working on and anticipating. But we did ultimately see some really meaningful movement across each of these priority areas, and we're really excited to be able to talk more deeply about those. So I will kick it off to Jess Zaccanino, our policy counsel, to talk a little bit about what we were able to achieve in the voting rights space.
All right. Hello, everyone. I don't know if my computer's lagging behind. Perfect. All right. Let's see. So it's my turn to talk to everyone about our campaign for no excuse absentee voting, which is also known as mail-in voting. So up until recently, as Chelsea Finney said, our election laws were quite restrictive and unnecessarily so. This is for history buffs. Back in the 1960s, we had a constitutional convention. And during that, a lot of our election law, for some reason, got adapted into our Constitution, including regulations around prohibiting early voting and requiring a small number of excuses to vote absentee. And once something is in the Constitution, it's much harder to amend. There's a much higher bar and a longer process.
Jess, you're lagging a little bit. Can't hear you right now if you're speaking.
We could go on to the
I am so sorry about that, y'all.
You're okay. You're okay.
I
We can
got,
hear you.
or can everyone hear me? I just got booted off my computer, which is a bummer.
Yep, we can hear you
Folks
now.
hear me?
I think Jess may have frozen again, but we can, to Gus's point, if you want to speak a little bit about SB 397, we can just flip the order.
Sure, yeah, we can do that. So for the other three legislative priorities we had this year are around immigrant protections, government accountability, and data privacy. We were essentially working with three bills, all in the Judiciary Committee at the beginning of the session. They all had public hearings in the Judiciary Committee back in March. And what happened was all three of those bills received joint favorable votes by the Judiciary Committee. But when it came to, well, they got consolidated. There were some language changes in each one of those bills, and ultimately they were all consolidated into Senate Bill 397, which was an act concerning democracy and government accountability on April 14th when it was passed by the Senate. And then a couple of weeks later, that same bill was passed by the House on May 1st. And Chelsea Infinity and Anderson and I are going to break down what those individual bills were before they got consolidated into SB 397. So we go to the next slide. So I'm going to talk about the ALPR bill, an act concerning automatic license plate readers before it was consolidated or amended into Senate Bill 397. Last fall, we had become aware that people in Connecticut were being investigated by law enforcement agencies outside of Connecticut for immigration and reproductive health care reasons using automatic license plate reader cameras that Chelsea Infinity was talking about earlier. These are cameras that are mounted on poles and bridges, even on police vehicles, and are taking pictures of every person's vehicle as they drive by, including recording the date, time, and location when those pictures are taken, saving that information in databases, and then making those databases shareable with law enforcement agencies, not only in Connecticut, but around the country, and including the federal government. So this is incredibly concerning when laws in other states are in conflict with Connecticut, and when police agencies and the extremist federal government are attempting to criminalize people's actions and behaviors that are legal here in Connecticut and don't share our values. So we had called for a moratorium on the use of these cameras back in November, which have been proliferating all over the state, and called for some statewide guidance around how these ALPR cameras would be used because they've essentially become tools of mass surveillance. And over time, what these cameras do is they are tracking people's pattern and movements, which is, again, extremely concerning and ripe for misuse and abuse. So as Chelsea Infinity said earlier, this has become a major issue for people all across the state. And there are actually multiple bills that addressed how ALPRs were being used, how ALPRs were being used during the session in different committees. We focused on HB 5449 in the Judiciary Committee and the version of the bill that was eventually passed out of the committee. We had a lot of back and forth discussions with stakeholders both in Connecticut and nationwide, including law enforcement and state agencies. And we were essentially focused on three things: the reasons that ALPRs could be used, how long the data could be held, and then who has access to this data. So what this means is in the bill or the law now, ALPRs cannot be used for immigration enforcement or to target people who are seeking or providing reproductive or gender affirming health care that is legal here in Connecticut. ALPRs cannot be used to monitor people engaged in constitutionally protected activities like protests and other First Amendment activities. ALPRs cannot be used to target people based on protected characteristics like race, ethnicity, nationality, gender identity, and more. Um, Police agencies, police officers can use ALPR data for specific limited purposes like locating missing persons, recovering stolen vehicles, or active criminal investigations. And then the data has to be deleted after 21 days unless it is tied to an active case. Additionally, ALPR data cannot be shared with federal agencies unless they have a court-issued probable cause warrant for specific data, meaning that ICE and other federal agencies cannot simply request bulk access to Connecticut license plate reader data. Um, I also want to mention a couple of areas of concern because legislation is never perfect, and this law is not perfect either. First, involving an exception to the 21-day retention period that allows data to be retained beyond that 21 days for purposes of identifying what's called in the law subsequent offenses. During some of the negotiations, proponents called these subsequent offenses as applying to parking enforcement or repeated parking violations. However, the statutory language is written in a way that is incredibly broad, which leaves open questions about how expansively agencies may interpret that. Additionally, the law also permits agencies to maintain internal watch lists or hot lists, and vehicles that are placed on those lists may also be subject to retention beyond that 21-day period. And the criteria for these hot lists is relatively broad and discretionary, which creates concerns for the ACLU about how these exceptions could be implemented and whether it could be undermining some of the bill's limits on retention periods. So again, the legislation is not perfect. Legislation never is. But this section of the law in SB 397 is a positive step toward creating statewide guardrails around how this technology is being used. And as we know, technology develops and changes very rapidly. So this is an issue that we are going to be continuing to keep our eye on and paying a lot of attention going forward. I think the next slide
Yep.
is
That's
okay.
fine. Perfect. Thanks so much, Gus. So, as Gus named, with these three different bills being amended into SB 397, this still says SB 397 because the former initial bill that we had been advocating for was this one. In essence, this part of the law creates a new way for people to seek accountability when state or federal officials violate their constitutional rights. People have had some legal options in the past, but those pathways have often been limited or very complicated. As we've seen, we have, a Supreme Court that is continuing to chip away at our rights as well and remedies as well. So for most people, remedy when this happens is unavailable in most situations. And so this law was incredibly important and needed because we needed a clearer path for people to bring cases forward when their constitutional rights are violated, especially by federal officials, right? As I've said before, we've seen an uptick in harassment and targeting by ICE agents among the many examples and agencies, right? The law also allows courts to provide meaningful remedies when violations occur, which was part of what we advocated for, and is another aspect of the bill the law that's really important. And that includes or can include financial compensation for harm that was caused. And that could also include a court order that requires the unlawful conduct to stop. Another key part of this part of the longer omnibus bill is that it also has some officer identification and masking provisions in the law as well. So it ultimately creates penalties for officers who intentionally conceal their identity in violation of the law, whether that be through a mask or through covering their badge or identification. It is important to note that that is a little bit different from the private right of action that I just described, above that, where individuals, if their constitutional rights are violated, they can sue in court. And part of that is because for the masking and identification requirements in particular, it does not create a private right of action in this law. So generally an individual can't sue an officer under that particular provision. Instead, enforcement really is dependent on, for example, a prosecutor bringing a charge or charging that officer who violates the law. And that is why continued public pressure and local accountability remain important on that particular piece of the law. And it's also worth noting that the final law was also not everything that we had hoped for. As Gus said, not every law is perfect. We strive for progress, not perfection. But it is important to name that an earlier version of, this particular part of the law did include language that would have restricted out-of-state National Guard forces or military forces from being deployed to the state of Connecticut without proper written authorization from our governor. That provision was ultimately removed before the law passed. And I mean, that was disappointing, but the fact that it had even been included in the first place, I think was truly a testament to our collective sustained advocacy, in particular around not using state resources for, to support federal immigration enforcement. And we do think ultimately that this bill still represents an important step towards strengthening government accountability and expanding options for people whose constitutional rights have been violated, because we do continue to see it happening. We think that regardless of the type of badge you wear, right, you are not above the law. And this gives us a little bit of a meaningful remedy or meaningful recourse to actually seek accountability when our rights are violated. And I will kick it off to Anderson to talk to us a little bit about the last bill that was also amended into SB 397 as well, which was SB 91.
Thank you, Chelsea. So the last bill that was amended into 397 was Senate Bill 91, Governor's Bill on Protected Areas. One of the most important pieces of the legislation because it creates a new category of protected areas in Connecticut. These include places like schools, hospitals, places of worship, child care centers, playgrounds. Under this law, law enforcement agencies, local, state, and federal, are prohibited from detaining or arresting someone for a civil offense within these protected areas. The goal is to ensure that people can access essential services, education, healthcare, worship, and community spaces without fear of civil immigration forces disrupting those activities. This law also creates accountability. Someone believes their rights have been violated, they could bring a case in Connecticut State Court and seek damages, including attorney fees. This is an important step to protecting immigrant communities and ensuring that official community spaces remain safe and accessible to everyone. Thank you so much. I'm going to kick it back to Chelsea.
Thanks, Anderson. We are going to head back to voting rights. I know Jess was having a little bit of tech trouble, so she may keep her camera off. I think we're able to hear you. It's a little choppy.
Yeah. How do I sound on your end? Better or turn off my camera? Okay, cool. I switched to different Wi-Fi network on my house, so hopefully it'll be better. All right, I'm just gonna start from the top because I don't remember where I lost y'all. But good evening again. I'm here to talk about no excuse absentee voting, which we also will call mail-in voting. So for history nerds, up until recently, our election laws are unnecessarily restrictive. And that's because one of the reasons why is because back in the 1960s, during our Constitutional Convention, many parts of our election law were adopted straight into our Constitution, which included prohibitions on early voting and the requirement of a small number of excuses to vote absentee. And because it's baked into our Constitution, it's a much higher bar. You can't just pass one law by simple majority vote. It's much more drawn out process. And as a result, it took over a decade of work to modernize our election system. And voting advocates, many of whom are in this call, I noticed some names, successfully passed 2 constitutional amendments allowing the legislature to change our laws when it comes to early voting and no excuse absentee voting. Both of those measures were very popular with voters and won with around 60% of people voting in favor. So back in 2023, the legislature permitted early voting, and we were at that point only one of 4 states that did not allow early voting in some form. And then back in 2024, we successfully passed the constitutional amendment that allowed our legislature to make new laws about early vote, or not early voting, absentee voting in the state. It didn't, pass a particular absentee voting model. It just allowed the legislature to legislate. And now finally, we got the legislature to legislate, and we got no excuse absentee voting over the finish line. So as Chelsea Infinity said, at first we thought that legislation would just remove the current excuses without building better elections infrastructure to ensure that voting is truly accessible and equitable. But because of years of work and a particularly strong coalition of voting rights advocates at the Capitol this year, we're able to pass a very long omnibus bill that not only removed excuses for voting absentee, but also worked to improve our existing voting system much more broadly. So in the realm of absentee voting, the bill made a number of changes to improve our absentee voting system beyond just removing excuses. So I'll say a few of them. It's a pretty long bill, though, so I won't be able to cover everything. So one change you'll notice for the elections this year, this is all happening in time for the 2026 election and primary. You'll be moving, we used to use these double envelope system when you voted absentee. That was changed to a single envelope system. This was an idea that came from the Secretary of State's office, but this part is actually where most of the errors occur in the absentee voting process. So the idea is that by switching to the single envelope system, we'll be able to cut down on the number of ballots that need to be cured, having the errors fixed prior to Election Day. Now, similarly, our state also didn't really have a process for curing ballots with errors prior to the close of polls on Election Day. So this new law finally has actually restated the process for curing ballots. We would love to see in the future a process for ballots that are received after the close of polls, but future sessions will be back there. The bill also allows town clerks to begin sorting absentee ballots earlier on the first day that ballots are issued, as well as other similar timing tweaks to allow a bit more efficient ballot processing. It also allows voters to request to automatically receive absentee ballot applications, not ballots, every election cycle. In the future, we'd love to explore expanding this to allowing permanent absentee voting status, which is something that many other states are currently able to provide. We just weren't able to get that this time around in session. It also will improve the ballot tracking system that we have, assigning ballots unique identification numbers, and then voters will be able to track their ballots like a package in the mail. This is something I've seen voters in other states get to take advantage of. And it also will crucially allow voters to be quickly alerted if there is an error in their ballot that does require curing. So we'll be able to communicate with voters much better in terms of being able to get them to come to the town clerk to be able to fix whatever issue they have. And then also crucially, it does not reduce the early voting period at all. This was something we were worried that we would see happen. There frankly just hasn't been enough elections with early voting in place to really be able to tell how it's working, such that to justify cutting any days. So we're glad to see that remain in place at the 14 days for the general election. That we fought for years ago. And while our focus this session was on no excuse absentee voting, this bill is like over 100 pages. It had a lot of other democracy and elections protections as well, which I'll just quickly run through a few of those. There's this prohibition on masking and law enforcement presence within 250 feet of election sites. This is really similar, a really similar idea to the protected areas aspect of 397 that we just talked about. There are, obviously reasonable exceptions. People are not going to be required to remove their religious head coverings, or, if they have health concerns, having a medical mask on to vote. So people won't get caught up in that. It also improves the ability of our Attorney General and Secretary of State's office to respond and legally intervene in various elections interference cases, including by explicitly stating in law that physical obstruction of somebody's constitutional rights counts as a civil rights interference that the AG can act on. And this is particularly important when we're thinking about polling stations, and maybe obstructing somebody from actually accessing that polling place. There's also many other protections for drop boxes, election sites, tabulators. I know this doesn't cover everything in the bill, but we are going to be putting out a lot more information breaking down HB 5001 over the summer, especially in the lead up to absentee voting. So now that I'm out of order, I don't know who I'm passing it back to, but I will pass it back to whoever that is.
We can go to the next slide and you can pass it back to me. So thank you, Jess. Thank you, Anderson, and thank you, Gus, for talking a little bit about HB 5001 and SB 397. I wanted to share a little bit of additional context with regard to what's next for us as an organization and as a department. So for us, passing a bill is only the first step, right? We don't just check a box and then keep it pushing. Laws only truly make a difference if they're implemented, if they're enforced, and if they're understood by the people that they're meant to protect. And so both of these laws, right, are relatively new. They're developing areas of law, and we are continuing to assess what different types of legal claims or remedies could look like in practice. And so one of our immediate priorities right now is implementation and enforcement. And so for SB 397 in particular, we are working really hard to develop an enforcement strategy that helps ensure that, our rights or the rights, and protections created by this law are meaningful in practice and not just on paper, right? It's, we recognize that we are seeing actively a lot of violations occurring still, even with this law having been passed, right? And that doesn't necessarily mean that, boom, the next day we're able to move forward with, say, a lawsuit, for example. We want to make sure that we're doing this with intention, that we're doing it the right way. And so we are pausing and making sure that we convene stakeholders. That's something we've already begun doing, including immigration attorneys. We held a focus group just last week. And we're planning additional conversations with some advocates, with additional community partners, just to make sure that we are doing our due diligence to help identify implementation challenges, monitor how this law is being applied, and assess potential opportunities for litigation with all of the rights that we have been seeing be violated, right? Education is another major priority for us. New laws can only be effective if people know about them. And we are right now working really hard to develop some guidance, some trainings, and some educational materials, about both bills. In particular, we are, preparing to launch a campaign, specifically an education campaign specifically around this new voting law. As just said, we have primaries coming up. It's an election year, right? And so we really want to make sure that especially affected, directly impacted communities, historically undervalued and underserved communities, understand the protections that have been created for them under both of these bills and how to use them effectively. And lastly, we're already looking ahead to 2027. So we are doing some internal work and also working alongside our partners to, yes, we recognize we've made some great progress, important progress this session, but there's still work to do, right? So we are working to evaluate where those gaps remain, identify lessons from this implementation phase, this education phase, and working to develop priorities for the remainder of the year, but also, more importantly, the next legislative session. As I said, earlier in this presentation, we are headed to a long session next year. So we have, even more of a unique opportunity to do some great work in 6 months, double the time as we had this year. And those are all really important pieces because our work is essentially shifting from simply passing these laws to making sure that they're actually enforced and understood and built upon in the years ahead, right? I'm going to kick it off to Anderson to close this out.
Thank you. So, every good organizer has an ask, y'all. And we built this one especially for you guys tonight. We want you to join us because the work is going to continue. Keep building power with ACLU-CT. Stay informed, attend advocacy days, respond to our calls. We respond to calls to action to keep you connected and take action together because together we can accomplish more. We can see the Connecticut that we want to see. And as Chelsea said, we're headed into a long session so we can use everybody's support and leadership and joining us and making a difference in our state and building power for our state. And I want to thank you guys so much for joining PPAD tonight for this debrief. And Chelsea, bring us home.
Thanks so much. I'm going to put this, the volunteer link in the chat right now for folks who are interested in continuing to build power with us, as Anderson said. This is the, I just sent it to the wrong link. There we go. This is the link to join. You can stay updated with us. We'll have a bunch of cool activities coming up. We always have our advocacy days. We have you can keep up with our newsletters, tons of opportunities for engagement and involvement. We do want to open it up to questions in case folks have specific questions. I know that some of them have been answered already. We're going to take a look now. Hold on one second. I do see the question here about are you working on U.S. Postal Service interference with absentee ballots as proposed by the president? That is something that our legal team is exploring, but that's a sort of wait and see. We don't have a concrete answer in this moment, but it's something that, we will certainly have an answer on soon. And then I recognize there's a couple of other questions that have been answered already. There is one question that is in the chat that talks a little bit about having courts since held that out-of-state military cannot be deployed without the governor's consent. I know that is not in the Q&A function. I can take that question. I will name that there was a recent Supreme Court case that left in place a lower court ruling that blocked the federal government from deploying National Guard troops specifically in the state of Illinois. They did signal in that decision that the president can't just deploy the Guard whenever he chooses and that there are some meaningful limits on that, but they didn't necessarily hold that a governor's consent is always required, right? It also didn't create a clear statutory rule that names that either. And for us, that's also why it's important to codify something like that, because it would provide a more clearable, durable protection instead of leaving it open to, future court interpretation, right? As we've sort of seen, courts can easily chip away at rights that they establish. And that's one of the reasons why we were, at the time, we were advocating for this before that decision even, even happened. But nonetheless, we do think it's really important to codify things like that to ensure that it's actually written in statute and we're not solely depending on, courts in those instances, because it has historically been the case that they are not necessarily, as reliable in comparison. So that's just one reason for the advocacy that we were doing around this at that time and why we were specifically looking at the time at an executive order, but ultimately turned and pivoted to trying to get something codified. There is a question here as well that asks, can you talk about why the provision regarding restricting out-of-state forces from being deployed inside Connecticut was struck? The governor also seems to refuse to sign an executive order on this topic. Why is there resistance to this? I think that's a really great question. A lot of the feedback that we got at the time was really not wanting to make Connecticut more visible to the administration. There were concerns around possible retaliation, and that's not to say that those concerns didn't necessarily exist passing an omnibus bill like the one we just got passed either. It was always a concern, but particularly on the issue of the National Guard, that was something that the feedback we got was just really centered on not wanting to draw more attention to us. And so that particularly was something that we heard from the governor's office, and they just refused to sort of budge on. I don't know if there's other additional context that I might be forgetting or not thinking about, Gus, but that more or less was the rationale that we got for removing that language from SB 397's initial version.
Yeah, and I don't have my response to that is not specific to the National Guard piece, but something larger where folks in Connecticut right now are want to see leadership that is being more proactive and willing to take steps to protect people in Connecticut and honor our values, rather than being reactive and waiting for something to happen before, taking steps. We saw that with the Trust Act in 2025 when there were courthouse protections in the original version of the bill that were stripped out as the bill made its way through the legislature. And it took a summer where ICE was taking people into custody at courthouses for the legislature to come back in a special session in the fall to finally put courthouse protections, to finally put those courthouse protections into law. And I think when it comes to the National Guard piece, again, we're looking for leadership from the governor's office, whether it's an executive order or through legislation, to make sure that our National Guard in Connecticut would not be misused and abused and sent to other states to do the things that are out of step with Connecticut values. And that's, I mean, so what we've been looking for is for our leadership in this state to take more proactive processes to protect people in Connecticut.
I also see a question here that asks a little bit about the impact of no masking on ICE in Connecticut. The way this law was written, the goal, from my understanding, is to ensure that even if you are a federal official, in this case, that would include ICE, you are required to still identify yourself, and there are only specific narrow exceptions with regard to wearing masks. So in essence, the goal is to ensure that what we have been seeing, random people being taken off the streets, random raids, violations of that nature. And we've been seeing people wear, ski masks and cover their face and hide their badge. The intent was to prevent that from happening. And as we've seen in certain instances in Connecticut, even recently, ICE is continuing to contradict what's written in statute. And that was a part of the law that did immediately go into effect. And it's something that they, continue to, in most instances, not abide by. For us, one thing that I was trying to sort of touch on throughout or in the presentation is that the way that it's written in the law, that particular section makes the violation a crime, but it doesn't create a right for individuals to sue if they see those violations happening, or if they are on the receiving end, right, or being unlawfully detained by someone who is masking and not abiding by the law. So if an officer does violate, if an ICE officer does violate the masking or the ID requirements, enforcement really is going to depend on law enforcement ultimately, and prosecutors deciding to bring charges in Connecticut, right? As an organization, obviously we can only speak to our own, to ourselves, right? Our own experience, and we can't we can't sue to force prosecution, to force them to bring charges. And so with regard to what the impact of that is, the main tools for accountability in those particular circumstances or predicaments are really for individuals to report those violations. So continuing to document them, to engage in some public advocacy, either with your local law enforcement department or your local prosecutors, local mayor, local board of alders, or town council, and really urge them to enforce the law and to bring those charges, right? That particular provision was written in that way. I won't say intentionally, but it doesn't give that private right of action. So it is going to require a little bit more local municipal work to ensure that our prosecutors are actually moving forward with those charges, and that these rights aren't just meaningless, just on paper. And in practice, we're doing what we said we were going to do, and we're actually complying with the law that we wrote. I'm looking at some other, so we have a few other questions here, and I recognize we only have a few more minutes due. I see one question here. Will there be a push to improve the elements that weakened SB 397 in the next session?
can take, I know on the ALPR section, there's already been a push to look at private companies and their uses of ALPR cameras. I think Senate leadership sent a letter to Lowe's and Home Depot trying to find out how the data that those companies are collecting is being used. So I think there will be a push to, because right now the ALPRs that are the guardrails that were created for ALPRs in Senate Bill 397 only had to do with law enforcement cameras, and there were some carve outs for like airport authorities and some parking enforcement that I mentioned earlier. So there may be a push to look at how ALPRs are being used by private companies in the next legislative session.
Thank you, Gus. There is another question here about can we share these slides with folks who are unable to attend? 100% can share these slides, and we're gonna share them with folks as well following this. So you will all have a copy. We'll share some additional materials that break down HB 5001 and SB 397 as well. And that will include, you know, enforcement rights. That'll include what the laws do, what it actually means in practice, and what you can do moving forward. I think we have time for maybe one more question. With expanded absentee voting, especially if permanent absentee ballot status, it seems like a good idea to increase accessibility and turnout, but what about privacy and risks of coercion?
Yeah, I mean, I'm still thinking through the answer to this, but I do think it pretty well that many other states regularly use this permanent absentee ballot status idea. And I believe there are some voters that are currently able to. Yeah, there are definitely some voters who are able to be on a permanent absentee ballot list, but those are mostly disabled folks who are voting from home permanently, I believe. I do not know about that part of law super well. But I do know that you know, this is about a 100-page bill. There are a lot of protections included alongside expanding absentee voting, especially around security at, you know, drop boxes. There are also limitations. I don't have it in front of me, so I don't want to get the law completely wrong, but there is a section that also limits who may be circulating the absentee voting applications. I know in the past that it has been pretty open to folks in general, but that is where some of the issues have occurred in terms of coercion, as you said. But there's more limitations on that, and I know that that's been a topic of discussion for a while. I know organizations like Bridgeport Generation now does a lot of really important work, especially around absentee voting and security. So they're another great group to look at, but definitely some work that we have to do in future sessions. Really, like, you know, polishing up the absentee voting system, especially as we roll out in this election.
I'd just like to add, Gus and I were at a voting event last night in Glastonbury, and we talk about having a plan for voting. So especially this year, with everything being so near and dear that we have is going to be on the ballot, we're urging everyone not to just go out and vote, but have a plan to try and bring someone with them, right? Just take some time, have a plan. We have that on our website, and we'll be rolling out some education campaigns about no excuse absentee voting, the ballots, and early voting, right? The deadlines and all that stuff. But I'm just asking you to plan your vote and plan to try to bring someone with you. Thank you so much for your time tonight. And we really appreciate your support. And we look forward to seeing you next year in the Capitol, if not sooner.
Thank you, Anderson. Yeah, definitely want to be respectful of folks' time. We really appreciate you all joining us. This also was recorded, so we'll share this recording, these slides, and our additional materials with all who joined. And you can feel free to share that with folks within your network as well. And again, please, please, please volunteer with us if you're interested in continuing to stay updated on opportunities for engagement, for organizing, for advocacy, and to learn a little bit more about our implementation and enforcement strategies as well. Thank you all. I hope you have a wonderful night.
Thank you, everyone.
Thank you.
Take care, folks.